The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The next case is in re Harris Teeter, LLC, and we'll hear from the appellant.
Thank you, Mr. Chief Justice, members of the court. My name is John Cockle-Reese. I represent the appellant Harris Teeter. Assisting me is my partner, Justin Hardy. I would like to reserve 5 minutes for rebuttal. This case involves the value for property tax purposes of the contents of certain Harris Teeter stores located in Mecklenburg County. So to be clear, we're not talking about the dirt, we're not talking about the building, we're not talking about the value of the intangible assets of Harris Teeter. We are talking about the contents of those stores, the freezers, the shelving, the meat slicers, that sort of thing. And in all, it totaled more than 7,000 individual pieces of property. Now, everyone in this case agrees that the value we are seeking to achieve is fair market value. That is the value at which this property would sell for between a willing buyer and a willing seller. More precisely, the issue before this court is, in determining fair market value for used grocery store equipment, the degree to which economic obsolescence exists and whether the Property Tax Commission's conclusion of law that it did not was correct. So before addressing the issue, however, we must take into consideration the burden of proof that applied. And in applying the IBM burden shifting analysis, the Property Tax Commission unanimously determined and the Court of Appeals unanimously upheld that Harris Teeter presented competent, material, and substantial evidence that proved that the county's value was wrong and that therefore the burden of proof shifted to the county. As I will address in a minute, the county presented no credible evidence as to the existence or absence, for that matter, of economic obsolescence, and so the commission's decision that it did not exist is wrong. So the case law and
Mr. Cockle-Reese, before
yes.
you get any further, help me understand something. I mean, if I'm reading the commission's order correctly, and the ultimate question is whether I'm reading it correctly, they appear to have held that as a matter of fact, they weren't satisfied that there was any additional functional or economic obsolescence, and that since the county's method had taken physical depreciation into account, there was not any need to do anything more. Is that a correct reading of the order?
I think that in essence, yes. They did find that the county proved there was no economic obsolescence and therefore held that the county's value was correct.
So is the question then before us whether there is substantial evidence to support those two findings?
Yes, and in our view, there is no evidence to support those findings.
Okay, so but the ultimate question before us then is whether there is, under the applicable standard of review, the ultimate question is there substantial evidence to support the commission's findings that, with the exception of the computer equipment that they did do some additional depreciation on, there was no basis for finding functional and economic obsolescence with the majority of the property here?
I believe so. Yes, sir.
All right, that helps me. Thank you.
All right. So the case law and appraisal rules state, I believe unequivocally, that the best evidence of fair market value is market sales of the same or similar type of property where an active resale market exists. Harris Teeter's evidence clearly showed, and the Property Tax Commission agreed, that there was an active market for used grocery store equipment. Furthermore, Harris Teeter's evidence clearly showed, and again, the commission agreed, that the competitive aspects of the grocery store business were forcing prices of used grocery store equipment to go lower. If you look at the commission's finding of fact number 8, the commission acknowledged that mergers and consolidations of various companies has resulted in store closures, thereby adding assets to the used equipment market. Similarly, the commission's finding of fact number 9 acknowledged that stores were now being remodeled every 6 years, and the removed equipment either went to the dumpster or the used equipment market. Additionally, finding of fact number 10, the commission acknowledged that economic conditions in general and regular remodeling of stores in response to changing consumer preferences added quantity to the used equipment market. And lastly, and most importantly, finding of fact number 11, where the commission acknowledged that it is reasonable to conclude that the marketplace for used equipment, even at the upper end of sales, is closer to liquidation value. So in other words, the commission concluded in its findings of fact that competitive pressures were forcing Harris Teeter and its other grocery store competitors to trade out existing equipment for new equipment, not because this existing equipment had ceased to function for its normal purposes, not because it was worn out, but only because competitive pressures and consumer demands required it. That increased the supply in the market, and with limited demand for such used equipment, that meant that prices, in other words, fair market value for this equipment, decreased. I would give the example of an automobile. I buy a new automobile. I use it for 3 years. Then my neighbor buys another new automobile. I decide I have to keep up with my neighbor, so I'm going to buy a new one. But first I have to get rid of my old one. Is my old one no longer doing what it previously did to take me back and forth? Does it no longer have utility? Is it worn out? No, but for an external reason, I'm decided to dispose of it. And what is the fair market value of that used car? It is what the market will pay for it based on the supply and demand.
Let me ask you sort of a couple of conceptual questions again.
Yes, sir.
Following you, we categorize the depreciation that's at issue here as either physical, I think I understand what that is. And we also talk about economic and functional depreciation or obsolescence. What is your definition of economic obsolescence? What is your definition of functional obsolescence? I'm going to make sure I understand that we've got our categories right.
Functional is the particular property, subject property we are attempting to value no longer is as useful to do the things it originally was intended to do. For example, computers. You may have a computer you bought 5 years ago. It still does the same things it did 5 years ago, but now computers are so much better that it is functionally less valuable.
Or to put it in more generic terms, functional obsolescence or functional depreciation results from a decision to replace a particular piece of equipment, perhaps before the end of its otherwise useful life, because you can get something better.
Correct. Much better stated than I did. Thank you.
I don't know that I'd go that far, but I appreciate your help.
Well, and I would say there may be some functional obsolescence in these assets, but that's not our point.
So the real issue then is economic obsolescence?
Correct.
Define that for me, if you would.
Well, so things external to the business of Harris Teeter and to the assets are requiring or at least suggesting that the assets be disposed of, again, sooner than their useful life would say so. Here, it's competitive pressure and also consumer demand. It was clear from the testimony of our appraiser that was not disputed by the county that consumer pressure is requiring stores to remodel on a more frequent basis than they used to. So again, it's not that Harris Teeter says this freezer is no longer useful. It doesn't do what I want it to do. It's all beat up, and therefore I've got to get a new one. It's simply that the customer coming into our store wants to see a bright, shiny new one, and therefore we're going to remodel our store. We're not going to remodel it and leave all this used equipment in here. We're going to get new equipment. So that is an external pressure that is requiring the disposal of the equipment sooner than its useful life would mandate.
Thank you.
Let me ask you this. So in finding of fact 15, it references Mr. Turner, but it says the property's apparent capacity to generate income greater than the industry standard is not an indication of economic obsolescence. Put another way, it appears that they're saying because this item is located at Harris Teeter and Harris Teeter is a successful operation, we should somehow value the item more. Let me ask the question this way. Is it your sense that the commission or that the commission used the fact that this property was located at Harris Teeter to increase or to influence the value, as opposed to if this property were located at Joe's Quick Shop?
Yes. So finding of fact number 15 is the crux of where the commission went wrong. Because if you read that starting on page 7 of the decision, the commission says, Mr. Turner testified further that he had personally developed income-based values. That statement is factually wrong because Mr. Turner did not develop any values based on the income. He simply said, Harris Teeter as a company makes money, therefore these values, this property is worth a lot of money, so there's no economic obsolescence. But in fact, he did not make any sort of connection between the income that Harris Teeter makes and the value of any assets of Harris Teeter, much less the subject assets. Further, the commission says, in order to determine for himself, that is Mr. Turner, whether the subject property was producing an appropriate return for the appellant. Again, that statement is factually incorrect. Mr. Turner did not make any sort of conclusion about the subject property, what income it could or should or would produce, and whether compared to the market it was more or less or the same. And the commission continued, and Mr. Turner determined that the subject property produced income greater than the standard for the industry. Like the prior sentence, that is factually wrong because Mr. Turner never connected any income, much less Harris Teeter's overall income, with the subject assets. And so the commission said the properties, that is the subject properties, apparent capacity to generate income greater than the industry standard is not an indication of economic obsolescence. And that's where they went wrong because, again, that statement is factually incorrect. Mr. Turner never was able, with the subject property, to relate any income to it and determine whether it was above or below market. Mr. Turner says he did an income approach, but he did not. An income approach would be, I own these grocery store assets. I lease them to Harris Teeter. That's a stream of income coming to me. I incur various expenses related to that. I pay the taxes on it, maybe I insure it. And so you deduct the expenses from the income, that gives you a net operating income. And if you capitalize that net operating income by a reasonable market cap rate, and that indicates the value of those assets. That is an income approach. There was no such approach done with these assets.
Mr. Cockle-Reese, if I understood what he purportedly did, I don't think is it fair to say that at least his claim was that he had used an income approach not to develop an overall value for the property, but rather to determine whether there was any economic obsolescence?
That is true, but what he did,
and if I think we agreed previously, if I understood your earlier answer, that economic obsolescence meant in essence that you would opt for some other newer, shinier piece of equipment rather than the piece that you had for economic rather than physical deteriorations or technological obsolescence.
Yes.
So is it your contention then that that evidence that the existing assets are not sufficient to generate a above average return compared to others in the industry has no bearing on the extent to which economic obsolescence exists?
Yes.
Okay,
And
tell me why.
okay, you've got to first of all, again, the profitability of Harris Teeter as a whole says nothing about the value of any asset, be it the contents, be it the real estate, be it the intangibles, any of that. So
Does it say anything about the value of the assets as used in the business as a whole?
as a whole, maybe. But again, it doesn't tell you anything about these specific assets, because it is possible that the real estate produces a return of 10% and the contents of the store only produce a return of 2%, where the average return for the market is 5%. So you would have to somehow connect the dots between this overall profitability of the company to say anything about whether the assets evidence economic obsolescence. Moreover, the more clear way to determine the value of these assets is the resale market, where a available, ready, robust resale market exists. We asked Mr. Turner, why didn't you look at the resale market? Here, our appraiser has 3,000 plus pages of the sales of various items that he's attempting to value. Why didn't you look in the resale market? And Mr. Turner's only answer was, well, I used this analysis of profitability as a proxy, close quote was his term. Why use a proxy when you have something that directly tells you what this property will sell for? Now, the county would, so our point being, there is no evidence from Mr. Turner, which is the only evidence that the county presented, that really tells you anything about economic obsolescence, because he did not connect the dots. Now, the county would have you say that, well, you're looking at the wrong thing. So Mr. Gibson sort of summarized better than I could in his opening argument where the county goes wrong. At page 24 of the transcript, line 22, he says, but what we're going to see here is what I'll call basically an index of prices in the secondary market, referring to the appellant's evidence, that don't reflect anything about value in use or value as a going concern. It's just you could buy this for what you could buy this for in the used market. And we would say to Mr. Gibson, bingo. Because the standard is fair market value. The best indication of fair market value is what it would sell for in the market. Use value is a totally different concept. Going concern value is a totally different concept. And I think that this distinction was best shown in the recent, not so recent, but relatively recent case of Parkdale Mills, where the Court of Appeals said, the dictate of ad valorem taxes is that the value of the property is the price at which the property would likely change hands between a willing buyer and an equally willing seller. By emphasizing the fact that Parkdale uses these facilities industrially to produce yarn 24 hours a day, the Commission's findings implicitly allow the county to measure the value of the properties as their subjective worth to Parkdale. Such an evaluation is obviously not the same as adequately determining the objective values of the properties to a willing seller and buyer. So, going back to your question, Judge Urban, the Property Tax Commission ultimate error was in that finding of fact number 15 at page 7 of its decision.
And,
it's there.
and again, the specific error that you contend is present there is that there is no evidentiary support for the determination that there was no economic obsolescence because the analysis that they used looking at income changes is irrelevant. Is that I didn't say that very well, but I hope I got the point.
I think it is largely irrelevant the way they did it, and certainly without connecting the dots between what portion of the profitability of the company as a whole is attributable to these subject assets, and therefore that somehow speaks to economic obsolescence of these specific assets, then that analysis just falls down completely because the dots aren't connected.
So again, let me try again and see if I can do better. Your argument is in essence that the findings of fact with respect to economic obsolescence lack sufficient evidentiary support because one, the entire approach is irrelevant, and secondly, even if the entire approach is not irrelevant, there is no evidence tending to suggest that the income that's earned from the stores has any relation to the value of the assets.
Correct. Yes, sir. I think that would be a good summary.
Did I do better the second time?
I think you did equally well both times, but I'll take the second one.
And Mr. Cockle-Reese, if I might follow up with a question, I'm actually looking at the controlling statute, section 105, 2283, and it talks very much about what appears to be an objective standard. You quoted from the Parkdale case about what role subjectivity should play in the valuation of property. Could you expand a little bit on your view of how subjectivity entered into this process for Harris Teeter, your client?
Well, I don't think subjectivity entered in terms of proof of our case on behalf of Harris Teeter. I don't think subjectivity did enter into it. Now, the commission seems to infer in some other parts of its holdings that, again, this property had greater value in Harris Teeter's hands to Harris Teeter than it did in the secondary market. There's no evidence that that's true or not true. It may be true, but even if it is true, it's irrelevant. That's use value. That's not fair market value. There is an inference in the commission's holdings, maybe, that this property, because it's part of an operating grocery store, has greater value, again, to Harris Teeter than if it were being sold in the secondary market. Again, there is no evidence to prove that that is true or not true, but even if it is true, that is going concern value. That's the value of the whole business or a huge piece of it being sold all at one time. And even if you did that, again, you would have to connect the dots and say, we're selling the whole grocery store. That includes not only the contents, that may include the real estate, may include the intangibles, the Harris Teeter name. So we have to take that purchase price and we have to allocate it down to those various assets. And that, in essence, is what Mr. Turner did not do with respect to his profitability analysis and the conclusion of the Property Tax Commission that he did, and that there were connected dots, is just factually incorrect.
Thank you.
So, someone else have a question? Okay. So we believe, and I think I've hit the nail on the head several times about where we think the commission got off the rails. So where did the Court of Appeals go off the rails? Well, we think it is best summarized on page 27 of the Court of Appeals decision. There's one full paragraph there, and it states that similarly in the instant case, taxpayer would have the commission value its property as if it were not integrated into its business as a going concern. And we would say exactly so. We say you don't value it that way. That's going concern value. Taxpayer suggested valuation assumes that each piece of equipment is due for replacement and headed either to the landfill or the glutted secondary market at the time it's valued. And we would say, no, we don't say that. We are saying this property is still useful. It still has utility, but external things are making Harris Teeter get rid of it sooner. And yes, it goes into the secondary market, which again is the best indication of fair market value. The Court of Appeals further says, likewise, the taxpayer's approach would result in equipment experiencing a drastic reduction in value the moment it is purchased, new and installed in the stores. I might quibble with the drastic part of that, but certainly when equipment is bought, the minute you take it off the new side and put it on the used side, just like a car, it immediately depreciates. But really here, the biggest factor forcing the reduced value for this equipment, again, is the oversupply in the secondary market and the limited demand, which again is caused by changing consumer interest, which are forcing companies like Harris Teeter to remodel on a more frequent basis. And then lastly, the Court of Appeals says the evidence showed that the taxpayer and its industry counterparts, in fact, did not deal in the secondary market for grocery store equipment when buying equipment or disposing of it. And we would say that's totally irrelevant. Whether Harris Teeter only buys new equipment or buys used equipment, that's irrelevant. The fact of the matter is what we're dealing with here is used equipment. We have to value it. The best indication of value is the used equipment market. So Judge Tyson, in his dissent, we think hit the nail on the head. He said, Mr. Rolnick, taxpayer's appraiser, testified that used grocery store equipment equivalent in age and specifications to taxpayer's property sold for prices drastically below the county's unadjusted appraised values from its depreciation schedule. He testified that these market sales showed that these low market prices for used grocery store equipment necessitated downward adjustments to any value estimated by the depreciation schedules used by the county. He further testified that this further market adjustments resulted in appraisal values consistent with true value in money, that is fair market value. And he further stated that the evidence is not disputed or rebutted by the county. Mr. Turner, that is the county's appraiser, blamed the low values in the used property market on one, consolidation of the retail grocery market. We would agree with that. Number two, the closing of stores that put greater volumes of used equipment in the market. We would agree with that. The policy of taxpayer and other chain grocery stores to not buy used equipment for its stores. We think that's irrelevant, but that's true. And four,
Counsel, you're well within your rebuttal time.
Understand. Thank you, Your Honor. I'll wrap it up. And personal property being sold as individual units and not remaining in place in a closed store. So he concluded that none of these factors, individually or in the aggregate, rebut taxpayers' unchallenged evidence of the personal property's true value in money, and concluded by saying when the market is limited and supply is abundant, demand and consequently true value in money is lower. So the burden was on the county. The county presented no credible evidence regarding economic obsolescence because Mr. Turner failed to connect the dots. The Property Tax Commission's conclusion that he did is there's no economic obsolescence is legally wrong. So we would ask this court to reverse the decision of the commission and the Court of Appeals. And we would additionally ask the court, because Harris Teeter's evidence is the only evidence as to fair market value in the record, that it would direct a finding in favor of Harris Teeter's value. Thank you for your time, and I reserve any other time for our rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court. I'm Ron Gibson. I represent Mecklenburg County. I will address the questions from Justice Irvin and the comments by Mr. Cochleries during the course of my argument. This court should affirm the Court of Appeals decision. The Court of Appeals correctly applied the whole record test to the commission's decision. It weighed the conflicting experts' testimony, decided the issues, and discussed the evidence of record. This is not a complicated case. It boils down to which expert appraiser's opinion of value should have been adopted. applying the whole record test requires affirming the Court of Appeals decision. Reversing the Court of Appeals, in my view, eviscerates the whole record test, and going forward, the appellate courts will be asked continuously to decide between dueling experts. The dissenting opinion should be rejected. It repudiates the AMP analysis adopted by this court. It ignores the whole record standard, and it rejects the cost indices and depreciation schedules adopted and used by the Department of Revenue for all counties across the state. The dissent calls this statutory framework for assessing business personal property an unadjusted, agency prepared, one-size-fits-all schedule of values. In Mecklenburg County, 30,000 plus businesses or business taxpayers list and have their property valued using this process annually, probably 10 times that number across the state. Taxpayers provide the information, and adjustments can be made at the listing phrase. The dissent argues that the majority and the commission were wrong to not adopt the methods proposed by the taxpayer. The dissent would force the commission to use that methodology. Under the whole record test, even if the majority believes that one valuation methodology is better than what was adopted by the commission, under the whole record standard, the court can't reweigh the evidence and substitute its evaluation. Before the PTC, there was a new valuation approach proposed. That is to value business personal property based on the secondary or used equipment market using internet-based information to determine values. This is not the market for buying and selling Harris Teeter property. That's an important point. The record was clear that Harris Teeter did not buy from the used market to fit its stores. Their appraiser confirmed as much. In its brief, Harris Teeter argues, and Mr. Cochlery's confirmed that today, that you have to look to the market in which equipment can be sold to determine its true value in money. That specific approach was rejected in the AMP decision. We all know AMP best for the principle of the presumption of correctness of the assessor's valuations. But another important principle in AMP, that is the ongoing entity assumption, is embedded in the appraisal process. The AMP facts are important. AMP, the taxpayer, the electronics components manufacturer, took the position that since it can only sell its in-process and raw material inventories back to its suppliers of brass and copper, that is, that's the only market for those items, then the only true value in money for these inventories is the scrap value. This court rejected that approach, pointing out that there was no evidence that AMP
I'll try to reach Mr. Gibson by phone. All right. Fred is going to be in contact with Mr. Gibson and is going to look at having him log out and back in so that we can get things going again.
Thank you so much.
Looks like we have your video back.
Thank you. I apologize. Don't know what I did wrong. At least I didn't say a bad word that was recorded for posterity. Although I can't hear you, can I resume?
Yes, can you hear me? Hopefully
I
you
can, Your Honor.
Okay, thank you. And these are the types of things that happen. So anyway, Mr. Gibson, you may resume at your when you're ready.
I will resume, and thank you. I'm not sure where I was. I talked about the new approach that Harris Teeter proposed, that was to value equipment based on the used market, and you've heard Mr. Cochlery's talk about that. And I started talking about how this specific approach was rejected in the AMP decision. We know AMP best for the principle of the correctness or the presumption of the correctness of the assessor's values. But in AMP, the taxpayer, AMP, the business that makes electrical connections, took the position that since it could only sell its in-process inventories and its raw materials back to its suppliers, therefore in a limited market, that the true value in money was scrap value. Well, the court rejected this approach, saying first that there was no evidence that AMP usually and freely sold such materials back to its suppliers. In fact, it didn't even sell its in-process inventory. So the same is true for Harris Teeter factually. There's no evidence of any sales or purchases by Harris Teeter in this used market. The court in AMP was clear that
I'm sorry, Mr. Gibson. What does the record reflect happens to used equipment of the type that's at issue here at Harris Teeter?
The only evidence in the record was my question to their expert. Does Harris Teeter buy from this market? He said no. Mr. Turner's testimony was that his research showed that Harris Teeter did not buy or sell in that market. And as I think I said, perhaps during the time I was cut off, Mr. Cochlery contends that it's the market where they can sell that's used to determine the true value in money. And I'm saying that this court rejected that approach in AMP.
Right, and I'm just trying to make sure I understand it. If that's not the appropriate method for determining value, then what is?
Well, it is, as Mr. Turner proposed, and as the Department of Revenue indices and depreciation schedules demonstrate. You take the cost approach, appropriately depreciate it. Now, you can argue about what the appropriate depreciations might be, but I believe that that's the true value in money, and that's what the AMP decision supports.
It stood my conversation with, excuse me, I think I interrupted somebody. Justice Hudson, was that you?
No, I was trying to interrupt you.
Well, go right ahead and interrupt. Everybody would probably appreciate it.
I apologize. I just wanted to focus on finding number 15 that Mr. Cochlery spoke about in some detail. And I interpreted his discussion as saying that the testimony didn't support that finding in several respects. And particularly focusing on the part of finding 15 that's on page 7 of the Property Tax Commission's order. I'm assuming that you disagree with that characterization. And if you do, wondering if you could please point us to where in the record we would find evidence to support Mr. Turner's testimony as it is discussed in that finding.
Mr. Turner's report begins, and I had it up on my screen before I was cut off, but it's in the supplemental record, and then it begins at about page 3585 or so, and I'll have that back on my screen in just a minute. But Mr. Turner analyzes Um, he discusses his income approach. And so I think that's the record evidence. He summarized what he found, what he did and what he found. But I think the commission, excuse me, the court should look at what Mr. Turner's evidence was in the form of his study. And what he says he did was he did an income analysis to determine whether there was economic obsolescence. And he concluded that there was not, and he cited three factors. One is the rate of return on the assets of these 6 stores. He did that analysis and found that it was above industry average. He looked at what accountants and appraisers describe as the purchase price allocation from the 2014 sale of Harris Teeter to Kroger. And he determined from that analysis that there was that these assets, again, having to use allocations, were worth over $20 million. And he analyzed the data from Kroger's annual reports about their robust return on invested capital. Those things led him to conclude that there's not economic obsolescence affecting these Harris Teeter stores. That's set forth in greater detail than any of us would want to review in that supplemental record. And because that record is about 4,000 pages, I have not gotten back to the beginning page. But it's at about begins at about page 37 and some
Okay.
change. And I
I've
can,
been trying to get it up on my screen as well without any success so far. Thank you very
but
much.
the point is,
Mr. Gibson, let me follow up on an answer that Mr. Cockle-Reese gave me. I think he and I, or at least I think I understood his answers to one of my questions to be that, at least in his view, the guts of the case revolved around the question of whether the discussion of economic obsolescence in finding of fact number 15 had adequate record support. In his argument, if I understood him correctly, was it did not for 2 reasons. One, that just simply as a matter of logic, the income that was earned on a store as a whole was not relevant to the value of the assets that are at issue in this case. And that secondly, even if that statement was wrong, there was nothing in the record that tied the use of the income approach to these particular assets. I think he told me something like that. What's your response to his argument that the material in finding of fact number 15 isn't subject to those 2 criticisms?
Mr. Cockle-Reese has conflated and confused what Mr. Turner did. First, Mr. Turner indicated that he did perform an appraisal based on the 3 traditional methods. Market, that is the replacement cost, the cost approach, which is what the DOR schedules use, and he did an income approach, but did not use it to value the equipment. He did not use his income approach to value Harris Teeter's property. He was clear. He used the income approach to test for economic obsolescence. And he found economic obsolescence in the area of computer equipment, and he made an adjustment to that universe of property. He also found functional obsolescence in certain other equipment based on his research and his interviews with Harris Teeter store managers during his site visits for appraisals to determine that some items of equipment were being replaced faster than the depreciation schedules would permit. And so he adjusted for those types of equipment. So to say that he didn't dot the
Thanks everyone for your patience. These technical glitches are frustrating to everyone, and particularly the person who's caught in the midst. So Fred is again reaching out to Mr. Gibson. And thank you, Madam Clerk. Mr. Gibson, I welcome you back. Sorry for all these difficulties that are occurring.
Well, as am I. I wish I could find the culprit and strangle him or her. But it might be me.
No, I just think it's.
I was getting ready to ask you if you really wanted to go there, but
In my world, these things just happen. So
I'm closer to saying that bad word now.
no need for that. You got, you see the timer, you've got 16 minutes and 5 seconds left in your argument, and you may continue.
Thank you, Your Honor. I'm really not sure where to resume except to point out to the court again that Harris Teeter's position in this case was specifically rejected in AMP. That is, the court indicated that just because the one market might be foreclosed, that's not an indication of true value. And the court went on and explained the various other ways in which value can be determined. Now,
Mr. Gibson,
yes,
I'll let Justice Irvin jump back in. He had asked a question, and again, all the distractions, I apologize for that, but I'm certainly curious to hear your response. And Justice Irvin, if you don't mind repeating your question, that would be great.
I think the question that I had asked when you had the difficulty that you have alluded to was, in essence, what is the evidentiary support for the statements that are made in finding of fact number 15 that I discussed with Mr. Cochran?
Mr. Turner's testimony and his report, his appraisal report, which is in the supplemental record, points out the study he did, which showed that there was no economic obsolescence affecting the property as a whole, although there was economic obsolescence affecting the computer equipment.
If I understood Mr. Cockle-Reese, he was saying, first of all, that the whole approach that Turner used was irrelevant, and secondly, that even if the approach itself wasn't irrelevant, it was fatally flawed because there was nothing that tied the value of the specific items of equipment that are at issue here to the economic performance of the stores. I think that was essentially his secondary argument. Would you comment on that for me?
The confusion is that Mr. Cockle-Reese confuses Mr. Turner's appraisal, especially the use of the income analysis. Mr. Turner valued the property here based on the traditional cost approach. He also did the income approach, but he did not value the equipment. In fact, he specifically said, I relied primarily on the cost approach to arrive at my value. He used the income analysis to test Harris Teeter's equipment or Harris Teeter's theory that they were subject to this significant economic obsolescence. And based on that income analysis, which is in his report in the supplemental record, he indicated that there's no widespread economic obsolescence. Exception being the two areas I discussed before I was cut off, computer equipment, and then he found some other specific equipment that was being replaced more rapidly than the depreciation schedules would suggest, and he made adjustments for those. But think about it. There's the approach proposed by Harris Teeter would across the board apply economic obsolescence to 7,400 items of property. That's just nonsensical. So again, Mr. Turner valued the property using the traditional method. He did these other analyses because they were important to the overall approach he presented to the commission. Now, this was the evidence that the commission relied on to determine that the county met its shifted burden. Now, we contended that that wasn't appropriate, that the commission shouldn't have reached that finding, but they did. So Mr. Turner's detailed approach in his testimony was what the commission relied on and what the Court of Appeals adopted. And based on the whole record test, Mr. Turner's evidence was satisfactory, I think, to meet that burden.
You alluded in the earlier part of your answer to this line of question to some evidence about valuation of this property that was done at the time of the purchase of Harris Teeter by Kroger, if I'm not misremembering. That information is not alluded to in the findings of fact in the commission's order that I can detect. Is that evidence relevant to a determination of whether there's sufficient evidentiary support for the methodology that Mr. Turner recommended?
It's relevant because it supports the ultimate conclusion of value. He did not use that information to value the property. He used it as a check, as further analysis that yes, the value I've proposed based on or arrived at based on the cost approach is actually supported by these other analyses. And that information is in his appraisal. He analyzed that sale, which occurred 1 year before the valuation in question. This is a 2015 valuation. That sale occurred in 2014. And Mr. Turner testified that information about the assets has to be reported to the financial authorities in a large sale like this. And he analyzed that analyzed that information, and also analyzed the rates of return of these 6 stores, concluding that they're earning higher than the industry average. That indicates that there's not economic obsolescence adversely affecting that equipment. So therefore, no downward adjustment would be appropriate for these Harris Teeter stores.
And there's some allusions in different parts of the briefs to manuals or other instructional guides provided by the Department of Revenue. To what extent are those documents relevant to the decision in this case?
Well, they're very relevant, and sort of going to the 10,000 foot level and bringing it down to this case. The legislature has put a statutory framework in place for the Department of Revenue to provide these schedules for the listing and valuation of business personal property throughout the state. Each individual assessor receives information from the taxpayer, and there can be adjustments made, and there's an appeal process before the local county Board of Equalization and Review. In this instance, these adjustments were proposed not at the BER level, but at the Property Tax Commission level. And there's nothing wrong with that. That's perfectly within Harris Teeter's rights because there's a de novo hearing at the Property Tax Commission. But at that level, this new approach was presented. So you had the county's assessed value, the approach presented by Harris Teeter, and then the county hired Mr. Turner to do an independent appraisal, which the commission relied on as supporting the county's ultimate value. Mr. Turner's value, as I think the members of the court know, was at $22.1 million for these 6 stores, whereas the county valued it at 21.4, and Harris Teeter valued it at I think 13.6 million.
Can I make sure I understand and this somewhat goes back to your characterization of this case as about dueling experts. But if we were to find that in this case the commission's order was not sufficiently supported by evidence in the record, would we essentially be saying that the cost approach to evaluating property, personal property in these circumstances is not an adequate approach?
That would certainly be the position I would take if I was a lawyer in a subsequent appeal. But what that finding would be saying is you're ignoring the independent appraisal submitted by the county, which was Mr. Turner's appraisal.
And if am I understanding the record correctly that the approach proposed by Harris Teeter's expert, it has not been accepted, at least by any other court anywhere?
It has not been accepted in North Carolina. The record includes the decision of the Florida Appellate Court, which rejected that approach. Mr. Rolnick's partner, Mr. Sazo, I believe, actually testified, but in this case, the testimony was it's the same approach, same database being used. So the only other court I'm aware of, and I did a search during this hearing, was Florida, which rejected this approach as essentially not being reliable enough. But in North Carolina, you've got the AMP decision, which I think requires that you look at the market. And in this instance, the used equipment market is not where equipment is bought and sold, so it's not a good proxy for value. Justice Earls, what also would be happening is that finding that this commission decision is not supported by the record would really be a rejection of the statutory framework that's in place. And I think that puts the whole process back to square one, if you will.
Am I correct in reading the commission's order or in looking at Mr. Turner's testimony that his view of economic obsolescence would vary depending on the profitability of the owner of the equipment? So in other words, Harris Teeter generates income, quote, greater than the industry standard. But if Joe's Quick Mart did not generate income greater than the industry standard, under Mr. Turner's approach, he would have assigned more economic obsolescence to Joe's Quick Mart than to Harris Teeter.
I don't think that is the way Mr. Turner described it. What he did was look at economic obsolescence, and he looked at it at several levels, looked at information at several levels to inform his judgment. He looked at the rate of return of these 6 stores. He looked at the cost allocated to this level of equipment at Harris Teeter in the sale to Kroger. And then he looked at the overall profitability and said, these 3 things suggest to me, as an expert in the area of appraising, is that this equipment is not subject to economic obsolescence. And again, he did not use that to value the equipment. He used that to inform his opinion as to whether there was economic obsolescence. Finally, Your Honor, I would only repeat what I've said earlier, and that is that the Court of Appeals majority and the commission, I think, accurately applied the whole record test. They weighed the evidence of the conflicting experts. They both described the basis for their decision. And if you look at the Turner report, and also look at the assessor's testimony about the process they went through to arrive at evaluation under the whole record test, the majority should be affirmed. If there's more time, I'll respond to any additional questions from the court.
Thank you,
Your
Mr.
Honor.
Gibson, for persevering through some difficult circumstances.
Well, thank you.
Rebuttal.
Thank you, Mr. Chief Justice. I will be brief out of necessity. I'd like to start by addressing a question from Judge Earls. You asked whether or not siding with the taxpayer would mean that you couldn't use the cost approach anymore. And the answer to that question is a decidedly no. The taxpayer used a cost approach here. So it would be, it's obviously not true that if you said the taxpayer's way of doing it was correct, you couldn't use the cost approach. But we used a market-based cost approach, which drives to market value, and that's the standard in North Carolina. So it is not the case that you couldn't use the cost approach. Mr. Gibson has said over and over that this is a new approach and that it hasn't been accepted anywhere. That is not true. This is the exact approach accepted by the courts in North Carolina in the IBM cases. It is a market-based cost approach. So we can talk about AMP, and we did in our brief. We don't think it says what Mr. Gibson thinks it says. We hope that you'll read that reply brief. But what I want to make clear here is you don't have to go back decades. You can go to AMP, or you can go to IBM, and you can go to Parkdale, and you will see that our position is entirely consistent with North Carolina law in those two cases. Finally, in the last 20 seconds, I will say that there has been, I think, rightfully so, a lot of focus on finding of fact 15. And what I'd ask you to do is compare that finding of fact to the other findings of fact in this case and see if you can marry them. We think that you can't. The commission acknowledges that there is economic obsolescence, but then says that there is not due to a analysis that does not connect the dots. So we hope that you'll remand this case to the commission to enter a decision consistent with our appraisal's value. Thank you.
Thank you, counsel. Thank you to everyone. Madam Clerk.
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.